I did suggest that a sum of $2,000 per month be granted presently.
I don't really agree with how much child support he's wanting. I'm not working right now.
Michael was getting unemployment insurance or unemployment pay, the $5,000 per year, when he had stated to me that he had made $80,000 a year. And if he only made $5,000 a month last year, that would imply that he made a $60,000 total sum for the year.
If I was unaware that my child was on Medicaid and like we had an agreement that, you know, he has my son covered and I can put my son on my insurance, and I wasn't aware of this. So I was just wondering how it falls back on me to pay the arrearages if I wasn't able to know that this was happening.
The stability there is just not there. And I'm worried because of my son's behavior. It's gotten worse over the last year, being floated from here to there.
Mr. Batterson during the hearing admitted that he voluntarily left his job.
The defendant father does not have a place to live. He's apparently an over-road trucker. We're asking that the change in circumstance would dictate that there be a change of physical custody only to my client.
Court will note the appearance of Ms. Pacino on behalf of the plaintiff, Mr. Scott on behalf of the defendant. This matter is before the court on the plaintiff's motion for child support. I have read all the pleadings in this matter. It does appear based upon that the court is going to have an evidentiary hearing to decide the ultimate issue, as there are a number of issues the court has to decide in this matter. Is there anything else you have to add, Ms. Pacino?
No, Your Honor. I do believe that the court will need an evidence. Would ask if this court could start some temporary support. My client has gone without support on this minor child in September.
Okay, Mr. Scott, thoughts?
Yes, thank you, Your Honor. I have reached out to Ms. Pacino. We have been working well together in my judgment, and I did suggest that a sum of $2,000 per month be granted presently, pending your review and or the friend of the court's review, because as the court may be aware, if Mr. Nailor had paid anything, it could have been determined voluntary payment. And so I'm happy to enter an order at this time at $2,000 per month if it's within the court's discretion to do that at this time, adjusted either upward or downward, depending on how you decide or how the friend of the court might rule.
Okay. Well, the court does note, at least Mr. Scott in his answer says at one point the parties had agreed to the $2,000 per month. I don't know if that's the case, and I don't know if the proofs will establish that, but at this point the court will order the sum of $2,000 per month, commencing on today's date, July 1 each month thereafter, subject to obviously modification as we proceed. And the court will schedule an evidentiary hearing to determine all the issues that we have to arrive at the correct support amount. Anything else, Ms. Pacino?
Nothing further, Your Honor.
Mr. Scott?
I have nothing further, Your Honor.
Ms. Pacino, if you would submit that order under 7-day, we will conclude, and then we'll be in touch with you. Is there anything else you need to do, Ms. Pacino and Mr. Scott, before we have an evidentiary hearing? Because I want to make sure if there's any discovery or anything you're doing that we don't schedule it before that.
We may need to have a brief deposition, Your Honor, just on some of the issues, but it would be not a great deal of time is necessary, probably 30 to 45 days at the most.
Okay. Ms. Pacino?
Attorney Scott and I have been working well together, transferring information as needed. So it's be appropriate.
Okay. What we'll do is we'll probably set it sometime later August, if that works into everybody's schedules, and we'll be in touch with you to see what works with your schedules and your clients as well. And then we will have a hearing. I don't think the hearing would take more than a couple hours, so we'll schedule it at that point.
Just a point of clarification. My client is in Minnesota. Is it okay with the court to do that via Zoom?
Yes.
Thank you.
Okay, thank you. You're free to go. Have a good day. Court will note that this matter is before the court on the defendant's motion to set aside referee recommendation in this matter. Defendant, go ahead. You can proceed. I have read your motion, so you don't need to reiterate all that.
Okay, I was just, I don't really agree with how much child support he's wanting. I'm not working right now. And I do have medical problems, as my doctor has stated, and I am working with a cardiologist right now. I actually have they're calling me later on today to do a heart monitor. So those are things I'm going through right now. I also have never mind.
Okay, well, I do note that you had stated in your motion that the doctor had wrote a letter saying about your medical condition, but there was nothing stated in the letter as to, again, a diagnosis or prognosis as to your inability to work. And so a doctor can say anything, I'm treating the person for this condition or that condition, but if it doesn't go to the person's ability to work, we in the courts and the referee as a lay individual, we can't assume just because the person's under the treatment of a doctor that they're not able to work. So I don't know. I do note that you had ordered a transcript and there was an excerpt attached, page 3 of that was attached, but unfortunately page 3 didn't tell me anything. So what you're going to have to do is, if you want the court to review the entire transcript, you're going to have to provide that to the court to be able to review that.
When I went up to the courthouse, that's all they gave me, is what I sent to you.
I have no idea what gave you, but again, a transcript of a hearing is more than 1 page. I can guarantee you that. So we need an entire transcript. And so what happens, the order will remain in place until further order of the court. And if you provide a transcript and the transcript would delineate that the referee made a factual or legal error, then the court will consider resetting the matter otherwise the order will remain in place.
Okay, when I sent it in, I got 4 pages that I sent in. I sent it to Mr. Welcher, you guys, and myself, and it is the full transcript is 4 pages.
Okay, all I can tell you is what the court did. I had 1 page.
I never got it.
And it was page 3, and that was it. So
It's with the whole packet.
you're gonna have to, well, you say that, I don't know how it got docketed or whatever. The court did not receive it. The clerk's office might have received it. I didn't receive it. Mr. Welcher says he didn't receive it. So you're gonna have to refile that so that we receive it. And again, then once we have the entire transcript, the court can review that.
Okay.
I got a question.
Go ahead.
Do you know when all this is supposed to start by chance? Like when she starts paying or when this goes into effect?
It would start, if you look at the order that the referee did, it tells where the order states the amount. Right up above that, it says effective date. That's the date it starts.
Sir, I didn't get it. That's why I'm asking you. I never got any paper, and then I called down there and the lady said that there was nothing in the computer.
You're gonna have to take that up with the clerk's office. We don't handle the files for the court. The clerk's office does, and I don't know what's in there or what isn't.
I figured you have a date on your paper in front of you that says when it's supposed to start.
I don't have it in front of me.
Okay.
So you're gonna have to get that, but it would state whatever the referee's order, the Uniform Child Support Order has an effective date on it as to when it's supposed to start.
Okay.
Okay, that will be the order of the court, and refile that, Ms. Welcher, and court will review it at that time and determine if there's any basis. Okay?
All right. Yes, I will.
Thank you.
I'll call up there. Thank you.
This matter is before the court on the defendant's objection to the referee order. I note, Mr. Taylor and I reviewed the Uniform Child Support Order that was entered back on 6/6/24, that various cases and ordered a child support review in this matter. I guess, is that your understanding, Mr. Magnuson, that there's a review that's pending in this case?
That is my understanding, Your Honor, and I believe that should take care of any issues that are before the court at this time.
Well, that's what the court thought. So, Mr. Taylor, what I'm gonna do is I'm gonna allow the support review to continue. And I hope that that will resolve all issues concerning support. If it doesn't, you can file an objection or a motion at that time to whatever the referee decides, okay? I think it's premature for us to step in when the referee is doing a review.
Right, right. Okay. All right. I appreciate that, sir. Will I be receiving any mail about that?
You should, if you keep your address, current address on file with the front of the court, you'll get it.
Okay, appreciate
Miss Moore, is there anything that you have?
No, sir.
Okay.
As long
Well,
as he gets that taken care of.
Hopefully that takes care of it and we get it resolved. If not, then Mr. Taylor, you can bring the matter back before the court at that time.
I appreciate it, Your Honor.
Okay, thank you.
All right,
Have a good day.
Thank you, Your Honor.
The plaintiff's motion to set aside referee order. Ms. Apsey, I do note that obviously it's clear in your motion, you missed the hearing.
I
and
did.
as a result, did not have any input. But notwithstanding that, what factual or legal error do you believe that the referee made at that particular hearing?
I was more based off of our custody agreement because I wasn't able to state that I had Michael as much as I do have him, because I have him Monday through Saturday throughout the day because his dad works first and I wasn't able to state that I work seconds, so I'm not able to have him at night. Otherwise, I would be taking him more nights.
Okay. Well, at this point, I will tell you that the child support formula doesn't take into consideration times that you have during the day. It only pertains to overnight parenting time. So that in and of itself is not a sufficient basis to object. And so I don't see anything that you've provided today, nor in the motion, that would change the referee's determination, unless you have something else you.
I did have something else I wanted to bring into the fact as well. I had just noticed on one of the papers that it had said that Michael was getting unemployment insurance or unemployment pay, the $5,000 per year, when he had stated to me that he had made $80,000 a year. And if he only made $5,000 a month last year, that would imply that he made a $60,000 total sum for the year.
Well, we don't take that implies or inference or whatever, it's facts.
Okay.
And you have to establish by facts, not by what you surmise or by conjecture. So the court can't take that into consideration just because you think it may be applicable.
Right.
At the time of the hearings, you have a right to bring up all your evidence in that at that time, and the referee considers it. Obviously, the referee didn't consider any of that because you weren't at the hearing to bring that up. So it's not
I
the
was accidentally
referee's
in the
fault.
wrong room. I was in this room instead of the referee's room by mistake last time.
Yeah. Okay.
In that sense, I was wanting to bring up the custody and the fact that I had tried to ask Michael for more overnights and do a 50-50 state, and he said that that wouldn't work for him.
Okay, well, regardless, custody is not an issue today. The issue today was the support amount. If you have a sufficient basis to proceed on custody, you can file a motion and the court would then consider it at that time. But again, that's not before the court today.
Okay. And then with the state of my employment, because I had mentioned that on there as too, as my unemployment or my employment was up in the air. I am currently unemployed. So that was my only other problem with missing that last hearing.
Okay, well, you're gonna have to file, if that's the case and that's occurred since the hearing, you'll have to file a motion and address it, because again, pursuant to again, the opportunity to due process, that the defendant then would have an opportunity to respond, and then we could potentially have a hearing if necessary. But again, you can't bring these up at this time.
Right.
When the other side has no notice of what you're bringing up. So the court's going to deny your request to set aside the referee at this time, subject to, if you want to file additional motions, you can file that.
Okay.
Okay?
Yep.
Thank you both. You're free to go. Have a good day. The matter is before the court on the motion of, I think it'd be Ms. Snyder to opt out of the front of the court services. Ms. Snyder, I do note that front of the court objected, saying that the child is on Medicaid and getting food assistance as well. Is that accurate?
No, sir, that is not accurate. My son is not on Medicaid that I'm aware of. And if he wasn't aware of this.
Okay, let me ask Mr. Hillman. Mr. Hillman, are you aware of the child receiving Medicaid or food assistance?
He is not. So, and I verified this with DHS. I called them and made sure that they closed the case completely. He may have at one point, but there's no, I made sure that they knew that that case needed to be closed, and they took care of that for me. That would have been, I think it was Friday. I got a hold of them the 28th.
Okay, well, let me tell you, under the motion to opt out, there's a provision, paragraph 3, that states neither party is receiving public assistance. There is no arrearage owed to any governmental agency that provided assistance. So I don't, again, if the child is off assistance now, I don't know if there is in fact an arrearage that's owed back to the state of Michigan. So what happens at this point, I cannot allow you to opt out until we know if there's an arrearage owed to the state of Michigan. So you'd have to get something through DHHS to confirm that there is no arrearage, et cetera, before the court would be able to grant your opt-out.
Okay, is that something I need to get, or what does that look like? I want to make sure.
One of you need to get it, or otherwise I can't let you opt out if there is in fact an arrearage owed to a governmental agency.
Understood.
Okay, if you do have that, what we'll do is if you come up with that, then what you can do is you can just renew your motion and attach to the motion any statement or anything of that nature you get from DHHS confirming that there's no arrearage owed to the state.
What would the arrearage be, just so I understand? I'm not sure that either of us are aware of how that works or what they
Well,
are.
if there was assistance paid for and on behalf of the child, then the state would have, again, they would have a lien against any of those, you want to call it a lien against any of the support payments. And what happens if they are accruing as a result of benefits being paid, they're accruing an arrearage of those benefits. So that would be it. If you get something certifying from the state agency that there is no arrearage, then I can allow you to opt out. Otherwise, I can't.
Okay, so I will call them and verify what that looks like.
You're going to have to get something in writing, and if you get something in writing confirming that the child is no longer receiving benefits and that there's no arrearage, then we can grant it.
Your Honor,
Yes.
I just have a question. If I was unaware that my child was on Medicaid and like we had an agreement that, you know, he has my son covered and I can put my son on my insurance, and I wasn't aware of this, so I was just wondering how it falls back on me to pay the arrearages if I wasn't able to know that this was happening.
Well, because it was paid, it was a benefit paid by the state, and they have a claim to reimbursement from those support amounts. And it's unfortunate you didn't know, but the fact is they still were making payments. And if they made payments, they're entitled to reimbursement. Okay.
It's interesting though, if I may, I have been paying insurance through my employer. Like I pay $400 a week for my health insurance for my son, for like everyone in my house. I don't know. I guess I'm not sure how they would have been paying for him in the first place.
I don't know either, sir, but I don't have anything before me other than the objection saying that, in fact, he was on Medicaid and food assistance. It may be an error. And if you get something saying that it's an error and you provide what happens, you can provide HHS with the information that he was on your insurance all along, then there would be no reason to have Medicaid involved. That may take care of the issue. I don't know, but I don't have anything before me that's going to allow you to make that decision. So get whatever you can and then bring it back up and then we'll address it. Thank you. You're free to go. Have a good day. Matters before the court on the defendant's motion to set aside referee recommendation and the substance With all in this matter, you state, and I quote, with lack of support in the area, it makes me skeptical as to the level of stability our children are going to receive. Is that the basis of your objection?
Yes, Your Honor.
Okay. And that's fine, but when you object to the referee, I cannot set aside a referee recommendation based on speculation as to what may happen. You have to demonstrate that the referee made a factual or legal error. And so what is the factual or legal error that you believe the referee made?
Well, Dylan is now back with his parents with our children. He no longer lives in Ohio.
Okay, and how that impact the referee's decision?
Because of the fact that my children have been moved from house to house to house in the last couple in the last year, I feel like the stability there is just not there. And I'm worried because of my son's behavior. It's gotten worse over the last year, being floated from here to there. And he needs to be in therapy, and I don't know if he is receiving therapy at this point because he's been bounced around so many times the last year.
Okay, well, if therapy is necessary, you always can file a motion seeking therapy. With that, Mr. Hall, what's your response?
Well, we actually moved back to my mom's house because I'm actually having a relapse right now. So, and he's in therapy. He sees Jessica every Monday at 7:30. So, we just moved back with my parents so they could help me with my kids, so I could possibly receive the treatment I need.
Okay. Well, in this matter, Mr. Hall, why don't you provide Ms. Hall with, again, information as it relates to whoever the child's in therapy with, so she has that information. Provide her with the name, address, and phone number for that particular entity. But
I don't have their number.
Well, find it then, sir. Okay. If you take the child once a week, you should be able to know where they're at, get their card, get their phone number, and provide all of that to her.
It's actually in-home therapy, so I don't take them anywhere, sir.
Well, then you have to have some contact. In-home therapy, do they come into the home? Do they go by Zoom? What do they do?
I've got where the number she texts me off from. They actually come into the home.
Okay, when the person comes in the home the next time, get their contact information and provide that to the defendant.
All right, sir.
Okay, but at this point, the court doesn't have any basis to set aside the referee. If that should happen in the future, Ms. Hall, you have a right to file a motion to modify the order, and you should do that if in fact you have a basis to do so.
So I do have a quick thing that I'd like to mention. In the referee's paperwork, it only grants me visitation with my daughter. I'm not really sure why that says that I can't see Junior until summer of 2025, and then he's able to come visit every other week. I feel like him and I not being able to see each other has really strained our relationship and has very much affected his mental health.
And ma'am, I don't know why that's in there or what happened, but you'd have to, all I would recommend is go back and get a transcript of that hearing, and the referee would normally explain in the transcript what the basis was for his determination, or it would be in his ruling, and then you'd be able to see what that is. But you haven't provided me with anything today that allows me to do the action that you've requested. So
Sir,
you can file a motion or you can take other action in the future, ma'am.
So his ruling was to get him regulated on his meds and go to therapy throughout this summer so we can get him stable. Then we'll start.
That's fine. I'm just saying based on what I have today, I don't have anything to, again, provide a basis to grant the defendant's relief. So the court will deny the motion at this time. So thank you. You're free to go. Have a good day. Court will note the appearance of Ms. McNiff on behalf of the plaintiff. This matter is before the court on the plaintiff's motion to set aside referee recommended order. I've reviewed your motion, Ms. McNiff. It's my understanding you ordered a transcript. Is that correct?
I have, Your Honor. We believe that the transcript will show that Mr. Batterson during the hearing admitted that he voluntarily left his job and offered no medical substantiation for his reason for leaving the job.
Oh, Mr. Batterson, what's your response?
That is true. I have, and since then I have tried to obtain my medical records. They were ordered and they said it will take 7 to 10 business days for them to arrive, and I have not received them yet.
Oh. Well, what I'll do is, I am going to want to review the transcript. So I guess I'll ask Ms. McNiff that as soon as you get that transcript, you'd submit, and notify the court that we have that. And I will review the transcript, and then what I'll do is we'll set a further hearing at that point. And in the interim, maybe the defendant would get a hold of whatever medical documentation he has, and then we'll determine whether de novo hearing is necessary.
Perfect. Thank you, Your Honor.
Okay. Court will note the appearance of Ms. McNiff on behalf of the plaintiff, Mr. Todd on behalf of defendant. This matter is before the court on the defendant's motion to hold plaintiff in contempt and to suspend parenting time. I've reviewed your motion, Mr. Todd, and I've reviewed the answer by Ms. McNiff. She has stated no, the client is not allowed any contact, and again, that he was at the home, but the children were not there, and that's how the pictures occurred, etc.
Yes, Your Honor. We have other picture verification. Mr. Edwards did not employ this person, but it is in fact Mr. McKediak's ex who has taken some of these pictures. So we would respectfully request at this point parenting time be suspended, or alternatively an evidentiary hearing. Quite curious that Mr. McKediak is apparently not living at the opposing party's house, but happened to be there when court was occurring. And how would the children not necessarily be at the home for that entire day? But the plaintiff was actually somehow not present as well. This is one of those situations where there is certainly a lot of smoke, and we believe that there is absolutely fire. And in terms of sussing this out, if we need to have an evidentiary hearing, we're happy to do that.
Well, I think based upon the plaintiff's response, I think we're going to need to have an evidentiary hearing. That's your thought, Ms. McNiff?
It is, Your Honor. If we're going to resolve this, I haven't seen any photographs that would indicate that my client is not telling the truth regarding this matter. And of course, children often go to other people's houses for an entire day. That's not unusual. So we stand by our answer. And if we need to have an evidentiary hearing, then we do.
What we'll do is we'll be in contact with both your offices. We'll set up an evidentiary hearing, and we'll try to get this matter resolved then.
Thank you,
Your Honor.
Okay, thank you. You're free to go. Have a good day. Court will note the appearance of Mr. Schaefer on behalf of the plaintiff. This matter is before the court on the plaintiff's motion to change custody, parenting time, and support. The court will note that it is 9:09 a.m. and the defendant is not present. The matter was scheduled for 9 o'clock. Mr. Schaefer.
Please the court, Your Honor, as set forth in our pleadings, the children have been dropped off to my client for substantial periods of time. The defendant father does not have a place to live. He's apparently an over-the-road trucker. We're asking that the change in circumstance would dictate that there be a change of physical custody only to my client. Joint legal continue on with standard parenting time to the father. We would ask that would be granted. If the court needs a hearing on that, it should be set for a hearing, but I think a temporary order memorializing that request would be appropriate.
Okay. Well, the court cannot change custody without a evidentiary hearing to address the best interest factors. So the court does believe the plaintiff has provided proper cause and change in circumstances to meet the VARCA threshold for an evidentiary hearing. The court will set it for an evidentiary hearing before the referee, and that will proceed at this point. So you're free to go.
No visitation at all, Judge.
Turn your video on.
If I say it again, I'm gonna find you in contempt. So when any issue happens before, I'm gonna have my deputies come get you, and your child will then go to Mr. Habib.
I stand behind my documents. For the record, I stand behind my doc.
You can stand behind whatever you want. Do not unmute like I asked you. I find you in contempt of court, 10 days in the DeKalb County Jail. Child will be presented to Mr. Habib.